Hi, everyone. I'm just waiting. I don't think I have anybody watching yet. I know Travis has been in the chat. So I'm just going to sit here and wait a little bit for some people to come in. Say hi in the chat if you're already here. Because it's showing me that nobody's here, so in case it's wrong. Well, where is, okay, now they have 3 people. It's like I'm sitting here talking to myself. I'm going to wait still for a few more people to come in. I'm sure people will come in a bit. Say hi if you're here in the chat. Hi, Rhonda. Hi, Sheree. Yeah, thank you for showing up. I know this is probably a topic that it seems like it's something that everybody's been waiting for, or these are topics that everybody is talking about. These are really hot button topics, and yet I know that a lot of times when stuff doesn't directly involve Steve and Brendan's cases, people just don't show up to watch these things. So I hope that we get a fair amount of people coming in to at least talk about this stuff. I only have one more person. I always feel silly kind of talking to just 4 people. Travis, are you here yet? I know you were commenting earlier. Okay, well, I guess we're going to get started. Anyway, today, the Supreme Court of the United States handed down made a couple big decisions. I don't want to say rulings because they didn't. Gosh, okay, I need to grab my phone or something or put it away. So don't message me. If you message me when I'm talking, I'm not going to see it. But they handed down some really big decisions today. And the first was with regards to, it's a civil rights case about whether or not members of the LGBTQ community, particularly people who are gay or transgender, whether they have the same right of protection under the Civil Rights Act of 1974 to not be discriminated against. I really said that in a roundabout way. I'm still waiting for people to come in. Okay, more people have come in, but they're not showing up as being able to view. Hi, Linda. Hi, Annie. Yeah, it's weird. First, I want to say that I am actually going to be probably reading a lot of stuff because everybody knows my memory's trash right now. And I was reading so much different stuff today that I'm not going to remember any of it. I don't read stuff or refresh my memory somehow. So I even put together some banners so that I would remember what things to talk about. There we go. Title 7 of the Civil Rights Act of 1974. I guess that's the first place we should start. And of course, I have that up here, the exact act somewhere. Okay, so just to give you an exact idea of what that act actually says, it's a federal law that protects employees against discrimination based on specified characteristics. And what it names specifically is race, color, national origin, sex, and religion. Okay, so that is what it specifically covers. So the biggest question that the Supreme Court had to look at was whether the intention of the Supreme Court when they wrote that, of the legislature when they wrote that a law, was the intent to include other kinds of, or discrimination against other kinds of people. And what the majority was essentially saying was that, and this went in the majority's favor. So yes, it was a 6-3 decision. I should mention that first. It was a 6-3 decision in favor of saying that transgender and gay people were protected under this Civil Rights Act, and they cannot be discriminated against. And I believe in all 3 cases that were brought forward, it was somebody who was fired from a job because they were either gay or they were transgender. And now with this passing, that says that, I mean, it seems like such a no-brainer. Just if you're like a moral and ethical human being, it seems like a no-brainer that you shouldn't be fired just because you're gay. I mean, Like, what does that have to do with how well you can do your job? Anyway, so as I was saying, what the majority is saying in this decision is that, I gotta think now, okay. Even though it wasn't specifically spelled out in the law, I just told you all the characteristics that are specifically spelled out. Does it cover other instances or other groups of people that couldn't possibly have been thought of in advance in 1974? They're saying, like, would they really think about the fact that, I mean, they weren't, when they wrote the law, they weren't purposely discriminating against transgender and gay people. They just didn't think about having to include that specific language in the law. So the majority is saying that it shouldn't matter whether it's spelled out or not. These are human beings, and they have the same civil rights as everybody else, and so they should not be discriminated against. Again, kind of a no-brainer. But where the issue comes in, and all of these cases have, or all of these decisions have the same kind of core issue, and that is whether the judiciary, or in this case SCOTUS, has the power to change or add to a previously established law that was created by the legislature. Or, like, because in general, okay, I'm gonna back up and go back to that. I'll do this, this explanation for dummies thing, because I know that it gets confusing to some people. Not that I'm saying anybody's dummy, I'm just using that phrase. I'm not calling anybody dummy, sorry. That sounded bad. Okay, that's not what I meant. But I'm trying to get to the comments, right? So there's no comments. Right, okay, so, okay, I'll go back to that. I'll get to it in a second. So everybody, in case everybody doesn't remember, there are three branches of our government: the executive, the legislative, and the judiciary. It's Congress's job, and it's the legislative branch's job to create the laws, make new law. The judiciary is supposed to essentially just interpret the law. But when they interpret the law, they're creating their own law, which is referred to as case law, or sometimes referred to as a precedent. And it's binding. So this is why they kind of blend together sometimes. And the question that is being asked by the minority in this case is that we should not, or not being asked, but it's being stated, especially by Judge Alito, which should not surprise anybody. Alito and Thomas were pretty strong in their dissent here, saying that they are overstepping their powers. They're creating laws and changing laws that is not their job. It's a job for the legislature. Kavanaugh had a much more gentle dissent, but he still dissented for the same reason. But he even said, like, this is a great day for those in the LGBTQ community. Congratulations on your win, but I can't agree with this decision because of the same reason. Because I believe that this was a job for the legislature, not a job for the Supreme Court. Linda, you're so funny. Now, again, though, we say that the judiciary is responsible for interpreting law. Well, the law says, as I said, that sex is one of the reasons that a person can't be discriminated against. And what Gorsuch was saying in the majority opinion is that sex should refer to, whether a person is gay or straight. Now, of course, you can sit there and turn it the other way around, and sex was just meant to include male or female, which at the time were the only two genders that were really recognized. But it wasn't meant to exclude any genders. Those were just the only two that people thought of at the time. So that's why it's kind of it's a really, I can understand both sides of it. I can understand both sides as far as, should the Supreme Court have this kind of power to do this? But I also think of it, for me at least, I think it's a good decision because, again, your job is to interpret the law, and if you interpret the law in the spirit of law, then it should be a no-brainer, and that these people should not be discriminated against. But conservatives in general do not like the spirit of the law. They like the letter of the law, which is why it's so surprising. The reason this surprised everybody was because Gorsuch is a conservative, or he's supposed to be. I don't think he acts like one a lot of the times. And so he was not only in the majority, he wrote the opinion on it. So to have what's traditionally thought of a conservative justice saying we should interpret this in the spirit of the law is kind of unusual, and actually, like, I mean, I think that's a good thing. That's what we need more of. We need less of the political ideologies and just doing what's right or wrong, in the Supreme Court. Like, we really do need that. Now, let me see what I wanted to say about this. Gosh, okay, I just have to go through some of this analysis stuff I wrote earlier. So Title VII's ban on discrimination. Well, yeah, okay, well, I already said all that, sorry. Now, sadly, I mean, these cases have been, I know some people said that it's sad that it took to 2020 for this to happen, and it is. And these cases have been like mired in judicial hell for years. I think one of them actually was a 2010 case to begin with. And sadly, there are 3 cases that they were looking at. In 2 of them, the people that brought the cases actually have died since they brought these cases, and their families had to continue on their behalf. So that's how long these have been sitting around, Well, I mean, I guess it didn't really matter time-wise because one of the people died from like skydiving accident or something, and the other woman had kidney failure. So I don't know how old they were. Yeah, he died in a base jumping accident in 2014. One of the guys. Now, let me see here. Yeah, I'm not going to go back and forth to what all the lower courts said, because it went back and forth to several different courts, district court, and then several different appeals courts, and then there was a dissension among the different circuits, and that's why they finally had to do something about this. It just took them forever to do it. There were a ton of conferences on this case. Let's see. I want to see what I want to say about this. So just give me a second. I just want to get some specific quotes. Okay, so let's see. Gorsuch began by explaining that the Supreme Court generally interprets a law by looking at how the public would have understood the law when it was passed, the ordinary public meaning of the law. So that's generally how they would interpret things. But here he's saying that the word sex means either male or female. Under the plain terms of Title VII, then, an employer violates Title VII when it intentionally fires an individual employee based in part on sex, even if other factors besides a plaintiff's sex contributed to the decision. And even if the employer treated women as a group the same when compared to men as a group. Yes, that's one of the things he's saying. I don't know. I probably read that wrong. I didn't put the right inflection on that. So Gorsuch went on to say, all that matters is whether changing the employee's sex would have yielded a different choice by the employer. As an example, Gorsuch offered the case of an employer with 2 employees who are both attracted to men and are, for all intents and purposes, identical, but one is male and one is female. If the employer files the male employee only because he is attracted to men while keeping the female employee, the employer has violated Title VII. And one of the arguments, as I said, from the minority was that Congress actually has kind of been putting this issue off too. There was a bill that I think passed in the House, but it was stalled in the Senate. And maybe that's one of the reasons why SCOTUS decided to just take the initiative and make the decision, because it was just stuck in congressional hell instead of judicial hell. So maybe they saw that it just wasn't going to move forward, and they decided to just make this decision themselves. Who knows? They'd never admit to that, obviously. But I mean, that could be a reason. Could have done it for that reason. He said, so then Gorsuch went on to say, discrimination against LGBT employees necessarily entails discrimination based on sex. The first cannot happen without the second. He said, there is no such thing as a canon of What is, I didn't even read this part. Never mind. I'm just skipping that because that didn't even make sense. Sometimes it's just, they're just, judges in general are just so long-winded and they can't ever just say what they mean. They have to have this long, confusing sentence to describe everything. Okay, so then he went on to say, all we know for certain is that speculation about why a later Congress declined to adopt new legislation offers a particularly dangerous basis on which to rest an interpretation of an existing law, a different and earlier Congress did adopt. So yeah, it's not their job to speculate why it hasn't passed in Congress. That's not, as we're saying, it's not their job to speculate why. I had this so much better in my head. I was like, oh, I was all prepared. I knew exactly what I was going to say, and now I'm just completely lost. So, sorry, everyone, bear with me. Everybody, like, I already lost like half the people that were here. I'm sorry, I'm stumbling so much. I totally did it when I was first thinking about this. Exactly, Linda. Yes, I said it. Civil rights is supposed to protect the civil rights of all people, not just some people. It's not, especially when it comes to something like this about like employer discrimination, things like that. It's like I said, what the hell does that have to do with whether someone can do their job correctly or do a good job? Or sexual orientation shouldn't even matter, you know. And that it's especially, you know, wrong if someone has been an employee and then they come out at, you know, at a later point and they're fired for it, you know, unless like if they've done a good job and everybody's had no problem with them, and they're getting fired just because the boss found out they were gay. Like, I don't know how anybody can say that is justified and that is okay. It's not. Travis, I might just have to have you come on because I'm like, seriously, I'm like dying right now. I cannot even find anything that I was wanting to say. I don't know why. Okay, so here's anyway more about what Alito, it says Alito filed a sharp dissent that was joined by Justice Thomas. It says, while conceding that the result that the majority reached no doubt arises from humane and generous impulses. So again, they're not saying they disagree that this needs to happen. He said, but there is only one word for what the court has done today: legislation. Okay, so he's saying that he compared the majority's opinion to a pirate ship, writing that although it sails under a textualist flag, that is, it purports to adhere to the text of Title VII, what it actually represents is a theory of statutory interpretation. The theory that court should update old statutes so that they better reflect the current values of society. If the court finds it appropriate to adopt this theory, it should own up to what it is doing. And he's saying that they should be. It shouldn't be the judiciary's job to update legislature based on, you know, the current you know what I'm saying. The current fabric of the country. Yeah, I don't know. Fen, I'm dying here. Just dying. I think people would like to watch me just be so confused all the time. Because it's entertaining, if anything. You can laugh at me. I wish I would have just highlighted what I wanted to say, but I didn't have time to do that. As usual, I didn't have time to read through the entire decision. The entire decision was like 172 pages, so I wasn't going to read the whole thing. There's just no way. Especially when you can break it down into a few sentences in most cases. So Alito again said, the real question before the court is not whether discrimination because of sexual orientation or gender identity should be outlawed. The question is whether Congress did that in 1964. It indisputably did not. So again, it's a really rare decision where it's like, you know, they kind of all agree on the end result. Nobody is saying that the merits of the case are wrong. Like, you shouldn't be granting these rights to people. You shouldn't be including them, you know, and not discriminating against them. Nobody's saying that, but they're saying that this is not the job of us. It's not the job of the judiciary, and it should be changed through legislation. And then Alito, as he did, said he warned that today's ruling is virtually certain to have far-reaching consequences that will include, among other things, threats to threaten freedom of religion, freedom of speech, and personal privacy and safety. He noted that myriad federal laws like Title VII ban discrimination because of sex, including the Fair Housing Act and Title IX, which bars discrimination in education. And he described the court's brusque refusal to consider the consequences of its reasoning as irresponsible, because it greatly impeded and perhaps effectively ended any chance of a bargained legislative resolution. So that's just him being Alito. And then it said that, again, with Kavanaugh, that dissented. And he said, he observed that the Supreme Court has previously stated, and I fully agree, that gay and lesbian Americans cannot be treated as social outcasts or as inferior in dignity and worth. But it is not the job of judges to make or amend the law. So, I mean, so again, that's pretty much an overview of what they're trying to say here. So I don't know. People can just ask questions, I guess, because I've just totally like screwed this all up. Did anybody actually get anything of all that, my confusion and my confusing rambling? Like, do you understand what the issue is with this? I said it's very rare for you know, like I said, the minority to actually agree on the merits of the case. But just, oh, here's Travis. He's gonna bail me. Oh, Travis, you left again. What happened? Travis is gonna bail me out a little bit. I know he'll have more to say. Oh, private chat. Where is he? Yeah, you were in and now you're gone. Travis, come back. Help me. Seriously, we have 6 people watching. Yes. You just missed me being a rambling idiot. And that's all I did because I just got so like confused with what I was doing. And I said I had it all so straight in my head when I started. And then I went blank completely. There's Travis again. Hi, Travis.
Hey, you're doing great.
Oh, you always do that no matter what I do.
No, you put it in simple terms. I mean, you can get in a big quagmire, but the thing that was really interesting about what's even the name of the case?
Which one?
The one that got decided today on Title VII.
Was it Bostwick? I'm trying to remember now which case it was specifically that they.
But is it Bostwick?
I was thinking it was Bostwick, and I'm like even that. Oh, Bostock. Sorry. Yeah, Bostock was one of the cases.
Yeah.
And then the other two, they were all, and then the other 2 cases were consolidated. So then the Supreme Court agreed to hear them all at the same time. So they were basically making the same ruling on all 3 of these cases.
Right, and we've seen that they do that frequently, consolidate cases with similar issues, if not identical issues. We saw that with the cases on same-sex marriage. There were 2 or 3 different cases across the country. First, it started as a federal law, interpreting federal law, and the Supreme Court decided that, and then they started looking at state law. The court frequently likes to go in a step-by-step approach, but this decision today was really interesting because you have people on opposite ends of the ideological spectrum, putting politics aside, but you know, the C word, conservative, and L word, liberal. You know, the justices are very well identified on ideological lines. They track everything. What percentage of the time that, you know, one justice is in the same group, the majority, as another justice. And it's no surprise that people at ends of the ideological spectrum are on, you know, voting the same close to 100%, yet those who are of the same ideological spectrum, they almost have perfect correlation. For example, Scalia and Thomas had over a 98% correlation that they agreed on votes together. So, Sotomayor and RBG, probably 70–80% of the time is somebody that's on the other end of an ideological spectrum. But in this decision, you had people of different ideological spectrums being part of the 6-3 majority. And really what was interesting about this case is that you had a very conservative justice, who you mentioned, who wrote the majority. That's unique in and of itself. So the way opinions are assigned is the senior justice on that particular side gets the first choice. So Roberts would have had the choice to write the opinion, but he assigned it to Gorsuch, and probably because he laid out that, it's going to be the basis of my opinion, is it's the plain text. So there's a couple of schools of thought on how you, if you're a Supreme Court justice, how you interpret, one, the Constitution, and two, the other part of their job isn't strictly the Constitution, but it's also in interpreting federal laws, federal statutes, which the Civil Rights Act of 1964 clearly is, and Title VII of that clearly is. And so there, one school of thought on how you interpret the Constitution is you go back, or the Constitution or a statute is go back to the body that created it, the framers in the case of the Constitution, or Congress in the case of federal law, and figure out what their intent was at the time. So that's one school of thought. They're called intentionalists, and they're and both sides of the political spectrum have justices that have used that form of interpretation. Scalia used it in his Second Amendment cases, and his the Crawford case, right to confrontation. His opinion went all the way back to what the law was at the time on confrontation, at the time that the framers were drafting it, and then even back beyond over to Old Merry England and what the common law was. And then the other main school of interpretation is textualists. And textualists just look at the text and what's the plain, ordinary meaning. It doesn't matter what Congress's intent was back in 1964 when they used the term based on sex. Doesn't matter if their intent was to include people who were LGBT. It's what does, if you interpret it plainly and give it a fair interpretation, what does it mean today? And textualists say, trying to figure out the intent, it has too many flaws, and it creates judicial legislation. It that the cons way outweigh the pros if you try and figure out the intent. Just go with the text, and it's up to the body, Congress, if the effect of laws, frequently what we call the unintended consequences, start to get too great, then Congress can go in and, amend the law, repeal the law, amend the law.
But that's one of the questions that we have right now is like, why Why is the legislature so afraid to put this in writing, to make it part of the law?
Well, and this is what justices, federal justices at the appellate level, what you hear them frequently complain on both sides, that the legislature didn't want to deal with it, Congress didn't want to deal with it, because they're the political body. And so let's say you're from a state where you may be on the fence politically, and this becomes a campaign issue, and you're worried that your opponent, whichever way you go, is going to come out and say, oh, you're anti-gay rights, or you're immoral. We know what all the arguments are, whether we find there any merit to it or not. But because, believe it or not, outside of urban areas, there's, in rural America, this decision is probably going to be upsetting to a lot of people. And so, to answer your question, on many, many issues like these tough ones, abortion, gay rights, the ones that we've been seeing the last couple of weeks over racial equality, those are tough issues, and they're politically charged questions. Like to keep the politics out of it, but the reality is that sometimes Congress doesn't like to deal with tough issues. Let's take one out of the moral sphere, but just for example, Social Security. Social Security is very, very important. It's critical to people clearly who are over 65. And guess what? Most people over 65 vote. We just know that historically. So it's like, it's an issue that you don't want to tamper with too much, Social Security. And you see it in every presidential cycle, that, scare tactics. This candidate tried to reduce your Social Security benefits, or this candidate, wants to do this. Although, I would say 95% of voters, including people who are currently on Social Security, know that there are ways to improve the system. But, you take a hotbed issue like LGBT rights or abortion or, gun rights, these things.
Some of that too. We're going to get to that too later, a little bit later.
Yeah, so. But sometimes Congress doesn't want to deal with the issue. And, there are studies about this, going into midterm elections and going into, the 4-year cycle for presidential, that, they avoid certain things, or.
Yeah. I don't even want to get into all of that, because that's a whole different,
Right. And there's just an example, but it's, a lot of judges, both sides of the spectrum, are like, this isn't for us to deal with. The statute's clear. It says based on sex. And if you fire someone, and really it's even more fundamental than that. These folks sued, and then they said it was on account of my status as X
Mm-hmm.
that I was terminated. And they filed a lawsuit, and then the court said, sorry, you don't fall into a protected class, which is age, race, pregnant. What are the other EEOC claims?
Well, that's the thing, like pregnancy was added later on, like.
Right, but by statute, but and then if you're over 40, there's another act that hooks you under that. But so to file an EEOC claim, you need to either say, I was discriminated against because of my race, age, gender, nationality, race, whether you're pregnant or not, and that's a good law. There was a time employers, if they got wind that you were planning a family and so on and so forth, that they'd just think of some other reason and they'd be gone, because it's an expense. And so they passed an act. And so if Congress can pass an act to protect people from age discrimination and sexual discrimination and racial discrimination, and the way they passed the act on sex, if you interpret it today, it applies to LGBT community. If that wasn't their intent and they don't like that consequence, or if circumstances change, they can go in and change it. But
we should probably move on, because we're going to be stuck on this for a while otherwise. Is that okay? Do you have anything else to add?
Oh, yeah. No, nothing else. It's just, it boils down to interpretation and how you interpret. And there's two main schools of thought, and that's why you have people from different perspectives interpreting it. And then you've already mentioned, now it's dumped back in Congress's lap, and then we'll need to wait and see how they deal with it.
Yeah, I don't even if Congress is going to deal with it at this point. Now that the Supreme Court has made their decision, I don't know if they're going to deal with it. But okay, so we need to move on to qualified immunity, and I know you have a lot to say on that, but I just want to go through some stuff first so I can get my part over with.
I'm just here. I'm interested to hear what your presentation is going to be about. I'm just going to sit here and listen, and then when people have questions, I'll try and help you out with that.
Okay. All right. If people have questions, hopefully I'll cover it enough that they don't have any questions, but okay. So let's talk about qualified immunity. I think everybody by now knows what qualified immunity is. And essentially, I just want to talk about some background. And I'm going to put the names of the cases up here just so that people can see, not just to remind me, but just so people can also see what case I'm talking about. Assuming I actually write the right date on. Nobody mentioned I had the wrong date on the civil rights, and I know that one. I actually knew that, and I had the wrong date up there. It's 74 instead of 64. I even knew that. It wasn't until Travis said it that I was like, oh wait, why am I looking at 74? It's 64. Oh my gosh, I'm so dumb.
Title IX came out in the early 70s. Maybe that's why people confuse 7 and 9 all the time. People do it all the time. Don't worry about it.
I didn't confuse that. I knew it was 64. I just don't know why I typed 74 and why I didn't notice I typed 74. That was it. Because I even said something earlier about being in the 70s and I knew it wasn't. But no, that's okay. Anyway, qualified immunity first came up in Pierson versus Ray, which was a 1967 case. And essentially what was that case involved priests, believe it or not. I can't remember how many, like 23 priests were sort of doing this freedom ride for justice.
13, and one was the son of Nelson Rockefeller.
Yeah, no, son-in-law. 13 were arrested, but there were like 25, or it was 15 that were arrested, I think, but it was 23 that started out with, that were actually involved in this whole thing. I can look it up quick. I'm pretty sure. Let me see the facts of the case.
You keep going. I'll look it up for you.
Yeah, because 15 priests were arrested, and it was 28 priests that were part of the group. They were from the Episcopal Society for Cultural and Racial Unity. So this was, again, like a civil rights type thing with wanting equality for people. And so they were doing this freedom ride. And they were congregated at a public place in Mississippi. I don't remember exactly where. And 15 of them were arrested because there was a stupid law in Mississippi that you couldn't congregate in a public place, which is stupid because, I mean, isn't the point of congregating to be in a public place? So 15 of these priests were arrested. And as Travis said, one of them was even the son-in-law of Senator Rockefeller. So you would think that that would help him. It did not. And what's the worst part about this is that not only were they arrested, but they were fined $200, which was a lot of money in '76, but they were also sentenced to 4 months in jail. 4 months to a bunch of priests that were congregating in a public place. I shouldn't laugh because it's horrible, but it's ridiculous. And 3 of them were Black, but this didn't seem to fall along racial lines. It seemed to fall around like I hate priest lines, I guess. I don't know what it was. But yeah, these poor priests, you're going to serve 4 months in jail for just basically protesting very peacefully and in your whatever, like just whatever, wherever they were at a park. I think they're at a park or something. So this is the case that then, so what happened was a higher court later on dismissed the case, obviously, because it was stupid. And that law in Mississippi has been changed or repealed or deleted or whatever you want to call it. So the higher court dismissed the case, as they should have. But after that, these priests wanted to file a lawsuit against the police officers for unlawful arrest and for violating their rights and all those other things. And what happened was in this case, in Pierson versus Roy, the Supreme Court actually ruled against them, basically saying that there was basically 2 things had to happen. They granted immunity to government officials only if the official believed in good faith that his conduct was lawful and the conduct was objectively reasonable. Now, obviously, it doesn't seem objectively reasonable to arrest a bunch of priests that were protesting, but there was a law against it. So that's why they're saying like it was reasonable for them to arrest them because they were breaking the law. Whether the law is reasonable or not would be a better question, because it was definitely not. But you also are dealing with the issue of a subjective issue of what the police officers' frame of mind was. They're saying that as long as you acted in good faith, well, who decides that? And so a lot of times they end up having to go to jury trials to decide if there was good faith or bad faith. So in 1982, in Harlow versus Fitzgerald, which is actually a Watergate case, they changed it a little bit. So this is kind of the current standing of qualified immunity. Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Therefore, the application says, oh, never mind, that was different. But what is that? Does that ring any bells for anybody? Those kind of phrases, clearly established law and a reasonable person would have known. To me, that sounds a lot like the same type of barrier that you have to cross or get over in EDPA. It's very similar. That it became such a hard. Gosh, I can't. Why do I have such trouble with words now? It became such a hard thing to overcome.
It became a high bar.
Sorry. The voice from Obama beyond corrects me. That's what I need. Just correction now and then. So anyway, what the problem is with this is that clearly established law is that they're essentially saying that unless there's been a case with a similar set of circumstances and a similar set of facts that has already been established, been ruled on, then you're not going to, like, they're not going to rule on it, because they're not going to, they're going to say that it's qualified immunity. The only reason is because there's no clearly established law already saying that. So, okay, let me just try to put it in terms like, so since there is no clearly established law saying that if a police officer kills somebody by kneeling on their neck, they could get qualified immunity. I mean, that's essentially what it meant. Now qualified immunity, when it was first established, when was it first established, Travis? Like 18 something, like the 1800s, when this was not qualified immunity, but when it was.
So when they passed the first Civil Rights Act during Reconstruction in 1864, not to be confused with the one in 1964, but they passed a Civil Rights Act in 1864, primarily geared towards the South, and it provided the same thing. And then some cases went up and they said, well, Congress clearly didn't intend to get rid of common law defenses that were in effect. And so that's what those cases were. They said, well, there's a common law self-defense, let's say. There was another type of defense that was available, but we don't need to go down that rabbit hole too much. But by the time the 1964 Act came around, they said, well, our prior precedent has said that this language in 1964, which is nearly identical to 1864, but the main thing it did is create a private right of action, meaning an individual could sue, not just a government, not just a federal government suing a state or an official. They said, we've held that common law defenses apply. And then that takes you back into qualified immunity as a type of common law defense, which is developed. But yeah, that's the history of it.
Okay, because qualified immunity was originally, the purpose of it originally was to prevent people from bringing frivolous lawsuits against police officers when they're doing their jobs, and to account for the fact that sometimes as a police officer you have to make split-second decisions, and that you shouldn't be held accountable if that split-second decision may have been the wrong one. That's essentially why qualified immunity started to begin with, but it has gotten so out of hand under Harlow is when it just really, they said when they added this part about needing clearly established law, that's where it's like, as I said, it's a bar that's too high to overcome, because you're saying that the case has to have a specific set of circumstances that has already been ruled on in order for it to be valid. And that's ridiculous, because there are so many different cases or things that could happen where you would want to possibly sue the police. They can violate your rights in any number of ways. And essentially what they're saying is that it's okay for them to violate your civil rights as long as nobody else thought of doing it that way first. I mean, that's kind of what they're saying. They're saying, like, yeah, as long as nobody else thought to violate your rights that way first, you're good. You can violate their rights because there's no clearly established precedent on it. And that's the part
and there never will be. It's a legal
That's why it's
22. It's a big circle. Well, show us a case where this has been held to be a violation of someone's constitutional rights. Well, I could show you 4 cases, Your Honor, but all of those got dismissed because they couldn't point to another case. And I'm trying to tell you, this happens. It's happened the same way in 3 previous cases, and it keeps happening. But because you're trying to tell me I've got to show you a case where this is held to be a violation of somebody's rights, I'm never going to get there. And that's kind of where we're at.
Okay, I just want to see what else I have going on here before I, okay. So then we come up to the same issue that we had with the last ruling. And that is that, okay, this one I have a hard time understanding, because it was the Supreme Court that enacted the qualified immunity doctrine. Okay, that it was not a law, it was something that Supreme Court enacted. They obviously amended it in Harlow versus Fitzgerald. Now they are saying this is a job for the legislature. And so it's the same question. It's like, oh, so should we actually decide, should we make changes here, or should this be the job of the legislature? So it's I think that they totally copped out on this one, because it's already a doctrine under their own law, their own creation, and now they're saying we don't have the right to do it, to change it.
They created it. It's their mess, and it evolved. But let's go back to the '67 case with the Episcopal priest.
Yeah.
What the police officers were saying is, well, why are you suing me? I was just enforcing a local ordinance. And no one questioned that had constitutional problems or whatnot. We enforced that before. It was a valid law in the books. I didn't have any ill will or ill motive. And so it was that subjective standard like you were talking about. And so the court said, yeah, we need to have some sort of reasonableness to this. We can't be second guessing and Monday morning quarterbacking police officers on the street. And there's even language in that decision that talks about, so we're going to put police officers in the position of deciding, well, I'm not going to do anything. I'm not going to enforce the law. I don't want to risk financial ruin if I'm wrong. And so they said if the officer had a good faith belief that they were properly enforcing the law, then, and this is different than what happened in Minnesota and a lot of other places. A completely different thing. We have an ordinance. No more than 10 people can congregate in a diner and a trailways bus station at a time because for safety reasons. And we asked them to leave. They refused. We arrested them. It had nothing to do with their age, gender, race, anything like that. So then it evolved, like you were saying. They said, well, we don't care what their intent was, because if you go by their intent, that's a jury question. And so all of these cases, whether they're, meritless, frivolous, have no chance, anything can happen in front of a jury. We need a more objective standard. So they said, we're going to look at whether it's objectively reasonable. So that worked two ways. The officer clearly could have had ill motive and whatnot that was developed because they, knew each other in high school or something, but that goes out. But then also what goes out is the officer saying, oh, but, I did it in good faith. I didn't have any evil intent. They said, we don't care. We're going to judge this by how it appears from the outside. And then it went, and so you had Graham v. Connor that looked at objective reasonableness in terms of use of force cases. And then Graham v. Connor also adopted a snapshot rule. We don't care what bad words or argument happened prior to the moment the officer decided to utilize force. We're going to take a snapshot and judge it objectively at the moment that the officer decided to use force. And they also said, we're not going to judge it with the benefit of 2020 hindsight. We're going to judge it based on what it really is, rapidly, quickly evolving circumstances. That was in the 80s. And then through largely Rehnquist, a lot of these opinions that you're talking about, Tracy, have Rehnquist behind them. And it was just to make it easier for municipalities. And the pendulum, I constantly talk about this pendulum. And so, and you'll see 15, 20-year gaps between these key decisions. And they'll try and the court will be confronted with cases and they're saying, oh, we're getting all these frivolous cases. And, the court will say, oh, yeah, we need to do something. And look at all these frivolous, unmeritorious cases that are brought. And they do something, and then the unintended consequence is people who have legitimate cases can't reach this lofty bar that they've created. So the pendulum, for the last, since the 80s, early 80s, has just continued to swing. So where are we at today? So there's this case, a person who was having some mental issues was put in a mental health holding cell that was covered in human waste from a prior person, and it wasn't cleaned up. And they were just in the most deplorable circumstances. And everybody agrees these are deplorable circumstances. They're in there 2-3 days begging to be moved. They finally listened to the person and moved them to a cell next door that had been cleaned, that had no toilet, no sink, no faucet. It just had a hole in the floor. Something that you would picture in the worst of the worst third world country, not in a facility designed to take care of somebody who's having mental health issues. And all accounts, no dispute, this person, as they're getting better, are sleeping on the floor in deplorable, unsanitary conditions. That's putting it mildly. And so they get out and they sue and they say, this is a clear deprivation of my rights under the 14th Amendment, under, all the constitutional claims that you have to have for a 1983 action. And it wound its way up. It got dismissed. It hit the appellate court. And the appellate court said, well, there's no case that says that 5 days is a clear deprivation of rights. We got a case that says 27 days. I mean, that's how ridiculous it is. Everybody agrees that this person's rights were violated. But how clear was it to the jailers at the time? And that's the lunacy that this professor at the University of Chicago School of Law, who's been advocating for a redefinition of qualified immunity for over 10 years, that's what their side of it is that you take a situation that 98% of us would agree no person should have to endure, but because there's not a case and never will be a case, because the next one's going to be, oh, well, it was 15 days of that kind of treatment, and they'll say, well, no, it's got to be more than 27 for a jailer to know it's clearly established. So let me just add one more thing and I'll let you pick it back up. So that's how you can sue under federal law. Now keep in mind, well, why are they suing in federal court? You know, it's more expensive, it's more difficult, you have all these high standards. Why, you know, why even go that route? And I'll tell you why they go that route. It's because nearly every state, all that I practice in, they have something even more onerous than qualified immunity, more onerous in some people's eyes.
Right, and they're actual
They
laws.
they have sovereign immunity, which means in these states, you can't even sue in state court. So my point being that, yeah, there needs to be changes in immunity on the federal level, but you know, it's not easy. This is going to affect you in the pocketbook, but you need to get your states to revisit sovereign immunity. And most states have a Tort Claims Act that allow, under very, very narrow, limited circumstances, an individual to sue a state. Usually it's for a traffic accident. A metropolitan bus hits someone in a crosswalk or rear ends a vehicle, or there's a big train wreck. They'll allow lawsuits for that, but they have insurance for that. But you can't sue the police in most states because they're protected by sovereign immunity. 1983 trumps state law, and that's why they sue in federal court. So I think part of what's being lost here is, yeah, that needs to be changed, but what's the situation in the individual state that you live in? If your rights are violated by a police officer, can you sue the city in state court? And I think you'll find that the question is no. And if we're looking at changing qualified immunity, it's probably time to be looking at what level of sovereign immunity should there be. Go ahead.
Okay. What I should have started to say to begin with is that most of these cases against law enforcement come about, they cite 42nd United States Congress Code, the 1983 is the statute. So you'll see 1983 mention a lot of these. And I'm going to paraphrase this because this is a confusing sentence. But what that law says is every person who subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. So you have a federal law that gives people the right to sue, but then the Supreme Court enacted the qualified immunity doctrine, which limits what, who you can sue and why you can sue them. And so there's a little bit of a struggle there, I think. And as Travis was saying, like that most states have their own qualified immunity type laws, but there is no federal law. And so maybe the Supreme Court finally wants the legislature to weigh in on this. I don't know, but that's just the law that most people are bringing these cases forward on that statute.
Every case that Kathleen Zellner has settled on behalf of wrongfully convicted individuals was filed under 1983.
Yeah, that's because that's the most common one. So one thing I do want to mention about this that is a little bit unusual is that now this was as far as I know, it was an 8-1 decision. So if it seems like right now we have so many people protesting, and the people who are fighting against this this injustice and the inequality are more liberal than conservative by far, and yet the liberal justices declined to hear these cases of qualified immunity. But the one person who wanted to grant cert, so that they could finally hear this, at least hear these cases, was Clarence Thomas, who is the most conservative justice on the panel, which really seems to go fly in the face of what you would normally expect from a conservative justice. But prior to this, Clarence Thomas had also expressed growing concern with qualified immunity in the case of Ziegler versus Abbasi, I don't remember. But in that case, Thomas urged the court to reconsider qualified immunity, which he considered a doctrine that substitutes our own policy preferences for the mandates of Congress. So Thomas is basically saying that it should have been a law to begin with. It never should have been brought forth to begin with by a Supreme Court doctrine. It should have been a law to begin with. So that's why it still makes sense under his conservative slant or conservative beliefs.
And Justice Cagle joined him. I'm not sure in what form.
Did you say Cagle? Kagan.
Kagan. Did I say Cagle?
Yes.
Kagan joined him either in that dissent or her own dissent. And one of those cases is that mental health patient I was talking to you about, but I don't know if that was Ziegler or not. I don't know I can't keep all the facts straight, but in that mental health case, Kagan and Thomas were in agreement that it needs to be revisited.
Are you sure you're talking about Kagan? Are you sure it was Kagan and not Sotomayor? Sotomayor has expressed her displeasure with it as well in the past. So I thought maybe that, I don't remember Kagan ever doing it, but
I could be confused on that. It was clearly from opposite ends of the spectrum, but I expected it to be Sotomayor, but it jumped out at me that it was Kagan. But they've been repeating that. They'll file. While I concur in the court's result, I think we're long overdue in revisiting this, and certainly Judge Thomas has been on that for quite a long time, and then some others have been joining.
Right. So, where we are right now with this is that, now this is interesting because I said that it's possible the Supreme Court, they'd never admit it, but it's possible they could have wanted to decide that case because they knew that the legislation was stalled. Obviously, legislation on qualified immunity has a lot of momentum right now, and so there is a bill proposal in with the Ending Qualified Immunity Act. It's in the House of Representatives. It was just introduced June 4th, 2020. And the day before, on June 3rd, 2020, the Senate resolution was called for, which asking for the same thing to basically eliminate qualified immunity. Now, I don't personally think that qualified immunity should be completely eliminated, because I do still think that police do need to have certain protections from frivolous lawsuits or from some things. There are good cops who sometimes make mistakes. They do things, but I don't see them as being corrupt or always being necessarily, abusive of power or anything like that. So I don't think qualified immunity is a bad thing. It's just that it needs to function as it was originally intended to function, not to have this high bar that essentially gives anybody with a badge a license to do anything they want and get away with it. That's just not right. So that's just my feeling on it. And you've probably seen, if you're in my group, I had a little exchange with somebody earlier that I couldn't even believe, I think I couldn't tell if she was being serious or not. at first because, you know, she was saying like basically like, why am I disappointed in this decision? We wouldn't have any police left if people were allowed to sue the police. And I was just like, what kind of reasoning is that? And I said that it's, you know, if they're poorly trained, that's a different issue. But we would still have police officers left, trust me, if people were allowed to sue them for civil rights violations. And we're not talking about suing them for anything. We're talking about violating the Constitution, our constitutional rights. So yeah, you should be able to sue them if they do that. And again, speaking from the wrongfully convicted side of things, where, you know, I've spoken to a lot of exonerees, we've read about a lot of wrongfully convicted people. And so essentially, according to this person, that they shouldn't be allowed to sue. You know, it's like, like that doesn't make any sense. When you talk about that much of an egregious violation of somebody's rights, they should absolutely have the right to sue, because the only way it's going to stop is if police officers and the prosecution are held accountable for their mess ups and for when they screw things up and when they put the wrong person in prison for 30 years. You know, someone should be able to be held accountable for that. So, so is there any other questions on qualified immunity before I just want to talk a little bit about the Second Amendment cases, which I haven't read like really extensively, but I'm just going to do a brief overview of that.
I have a question. So what did they actually decide today? Did they decide they weren't going to hear those 11 cases?
Right.
Did they issue some sort of, did anyone issue an opinion, or was it just?
No, all that was, hold on, I can actually answer that for you. I just had it before. Let me just get to that page. Yeah, no, they were pretty much just summarily, just like with no explanation. Most of them were dismissed, except for the one that Thomas dissented on. That's the only one that said anything, and it was just a little blurb basically saying that that he dissented. Okay, I did have this a second ago. Where did it go?
Okay, so they issued an order denying cert on the 11 cases, and then on one of the cases, as the right of a justice to do, they can file a dissent as to why they disagree with the court's refusal to hear it. And then people are familiar with Brendan's case that reached the court, and all it was a order denying cert without any explanation whatsoever. And these 11 cases have been going from the court meets every week, and they have a conference, and they get around like, well, do we want to hear Smith v. Jones? Yes. Okay, we're going to grant cert. We have 4 votes, cert granted. Smith v. Jones and Jones. We want to hear, no, we don't have 4 votes. Okay, let's get rid of it. Then on these 11, what frequently happens is, okay, well, we've got amicus from a lot of really important people, you know, okay, let's get further briefing from the parties, or let's wait. Basically, they tabled it, I think it's something like 11 times in a row, and it was now at the point where if they were going to be considering one of these cases, they wouldn't be set for oral argument until next term. And you're going to be getting into that with the Second Amendment cases. I think 1 or 2 of those got scheduled for next term, but so I'll save that. But so these things were just kind of trailing along, and everyone's been wondering for months. We've been tracking these things, those of us who deal with qualified immunity, and it's like, what are they going to do with this? They're going to take it up and this, that. I suspect that the fact that there was talk about legislation was the nail in the coffin on them revisiting it. They're like, okay, we're going to defer to the legislature. They're talking about doing something, you know, we'll let them handle it. And that's why they went ahead and denied cert on all of those. And Thomas, who's been crying out for change, I think wanted to go on record saying, I've been telling you guys, we need to fix this. And I'm gonna say it one more time. And so I suspect they'll give the legislature, the Congress, a chance to make some changes. And then, you know, if for some reason that stalls out, they're going to have to probably take a look at this next term.
I'm trying to. Oh yeah, okay. It was in Bracey versus Baxter versus Bracey is the one where where Thomas wrote a dissenting opinion on the denial of certiorari. So, I just have to look real quick to see what he said it exactly. So the Sixth Circuit in this case said that the Sixth Circuit held that even if the officer's conduct violated the Constitution, they were not liable because their conduct did not violate a clearly established right. Okay, so this is one of those cases where it's saying that, you know, there's no clearly established right, and then Thomas is basically saying the same thing he said in the Abbasi case. Because our 1983 qualified immunity doctrine appears to stray from the statutory text, I would grant this petition. So it's basically just, again, him saying the same thing, that he questions the jurisprudence of qualified immunity, and so that he thinks that it should be changed. So yeah, so that's what he was dissenting on for that case. So it's Baxter versus Bracey. Okay. Okay, I have questions. Hi, Hugh. Hugh, I was fumbling around a lot. I wish it had been more interesting, but we get to the point eventually. Yeah, and SCOTUS, and that's the point though. SCOTUS is not about delivering justice. They're not. They're there to interpret the law. That is it. That is really supposed to be the only job of the Supreme Court, because they don't review verdicts. They do not establish whether someone's innocent or guilty. They do not. They just review constitutional law, and they interpret it when there's questions. So actually, delivering justice isn't really necessarily part of their job. So it seems like kind of strange. I mean, because obviously it should be part of their job, and it is to a certain extent, but in a lot of ways it's not. So I just wanted to real quick end this. I said, are there any questions on qualified immunity? I think we've all got it covered pretty good here, what we're saying. And I said there are proposals now that are first going into Congress about ending qualified immunity, and that could be why SCOTUS decided to pass the buck here, is because, you know, they want to see what it does in the legislature first. And one of the problems, in addition to what Travis said before about how you need to clearly establish law, but somebody's got to be the first one to establish that law. So it's a catch-22. And it works the same as that, in general, if you're the first person that's going to bring a claim under a specific set of circumstances, you're going to be denied. So that prevents a lot of people from bringing those cases forward. So it's another type of, it says a catch-22 that is actually not functioning the way it's supposed to within the system. So last thing I'm going to talk about is that there was also a denial of cert today in some cases involving the Second Amendment rights, which is, you know, obviously the right to possess and bear arms. So I mean, let's see, in Columbia versus Heller, the Supreme Court held that the Second Amendment protects the individual right to possess and carry weapons in case of confrontation. So for the core purpose, lawful purpose of self-defense, it says. Well, what's happening now is that these cases that were brought up, and again, Thomas is the one that actually is only just one that dissented, I think, again, on this. Let me just look. Oh no, it was a 6-3 vote that this case was moot. Which was the one they're talking about? It's okay. The court denied 9 of the 10 petitions without comment. So there are 10 petitions about the Second Amendment rights that they denied without any comment. But again, Justice Thomas dissented from the denial of review in a specific case, Rogers versus Grewal. And the problem with that is that it was a case that hailed from New Jersey, which grants licenses to carry a handgun in public only if the applicant can show a justifiable need. The state has defined justifiable need to mean a special danger to life that can only be avoided with a permit to carry a gun. And then let's see. Actually, Kavanaugh did join him in part on this case, and again, he's considering it an onerous burden to put on somebody that they have to spell out, or they have to establish that they have a justifiable need for it first before they can get carry a handgun when it's supposed to be protected by Second Amendment rights. And what Kavanaugh says is that, I think this was Thomas, observed, the Supreme Court would almost certainly review the constitutionality of a law requiring citizens to establish a justifiable need before exercising their free speech rights. So it's like they're not required to establish a need before they are protected by freedom of speech. And as he says, it seems highly unlikely that the court would allow a state to enforce a law requiring a woman to provide a justifiable need before seeking an abortion. However, today the Supreme Court simply looks the other way when faced with a petition challenging just such a restriction on citizens' Second Amendment rights. So that is essentially where they stand on that. I don't know what it's going to take for a case to be brought up again on this. So. But there was a lot of cases that they just said they're not.
So it's like a lot of issues that they work in increments, just like Thurgood Marshall had a definite plan on how to achieve desegregation of schools, and he went step by step, and he went higher education first, down to high schools and primary education, but he went step by step. I think he argued before the Supreme Court 33 times and won 30 of those cases, but he didn't start with Brown v. Board of Education. So like a lot of issues, whether it be Roe versus Wade, and people have been trying to chisel away at that step by step. And I'm not going to get into who's right or wrong. I'm just giving you the practicalities of the way law works in the constitutional arena. Then you had the Heller decision, which started out first. It was a DC ordinance, and so that's federal law, and they got that held unconstitutional. I don't think anyone was allowed to own a firearm in the district, period, even for home protection. So that federal ordinance got overturned. Somebody saw that and said, okay, let's get that applied to the states. And so it was either a Chicago ordinance or an Illinois state law. And they said this, same thing applies. Second Amendment is clearly designed to allow someone to protect themselves in their home. So now this statute in New Jersey is in order for someone to be able to lawfully carry a gun outside of their home. And so they're trying to advance the idea that the Second Amendment doesn't stop at home protection. It's personal protection wherever you may be. Again, I am not advocating one side or the other. What I'm trying to point out is that this is an incremental step from the Supreme Court's last decision. And that's done in the search and seizure context. It's done in the qualified immunity context, both ways. The city, the attorney for the city who's being sued, argues that, 5 days in unsanitary cell is not a clearly established violation of law. We have 30 days, but 5's not enough. And so they're arguing these increments, these steps, that it shouldn't be the subjective intent of the officer. It should be what's objectively reasonable, that people looking outside the situation can judge. It matters not that the officer was acting in what he thought was good faith. If what we see from the outside is purely evil and there's no good reason for it, that's what should control. So all of these things are increments. And until finally one day you wake up and the court's like, oh my gosh, we've incrementally swung the pendulum all the way over here. We better let Congress deal with this.
Okay, so so that's pretty much everything. If anybody has any questions, thanks to everybody for sticking around. If anybody has any questions, oh, you saw that? Yeah, I forgot to mention that. Right before I came on, Brendan sent me an email and said that his entire unit all tested negative for COVID. So thanks, Fen. Because yeah, I actually just got an email from him right before this. So yeah, that's good news. And I believe Steve is recovering just fine from his bout with the virus. So, but they're still having issues, not being able to get the phone a lot. That type of stuff is still, because they're still on lockdown. I don't know when that will be lifted or when they'll be allowed to have visitors again, which is unfortunate, but you know, they got to be careful. So yeah, so Fen, thank you for bringing that up, because that is actually really great news. Anything else, you guys? Otherwise, I'm going to wrap it up. I actually have to try to go to bed early tonight.
If they have something, they can put it in your Facebook group and we'll try to get to it, won't we?
Yeah, they can comment under the video, where I posted the video or whatever. Yeah, that's fine. Just make sure, but there weren't that many people here. So I thank you very much to everyone who was here tonight. I appreciate it. So I don't know when I'm going to be on during the online rally. I'm going to be on with Jane for sure, really early in the morning at like 5 a.m. my time. So that means that I'll have to stay up all night, because I am not a morning person. I can function just fine if I stay up all night and it's just a continuation of the evening. But if I try to go to sleep and wake up, it's not happening. I am not going to be a nice person at 5 a.m. So I'm going to do that. And I might actually even be, since I'm going to be staying up all night, I might actually live stream myself a couple hours before that, just to give me something to do in the middle of the night. So I know all my US friends are going to be sleeping, but if anybody is overseas, just look for that and keep me company. I don't expect there to be a lot of people. I just might be chatting, just general chat anyway. So that's the next time I'll be on. So that will be, is that Friday or Saturday? What day are we doing? No. Fen, which day is that? Is it Saturday or is Friday or Saturday? I think it's Saturday, right? Okay, she'll let me know. So just again, if you subscribe or if you hit the little bell on there, it will notify you whenever I go live, and you don't have to worry about missing anything. Okay, that's it. Thank you, Travis, for being on with me and helping me get through when I was struggling a bit. I appreciate it as always. And why are you in the dark?
I came outside where it was quiet, but thanks for having me on, and you were doing great. Hope I didn't confuse anybody, and see everybody Saturday, and happy Father's Day if I don't talk to everybody before Sunday.
Yeah. Okay. Thanks, everyone. Good night.
Bye.